We're returning from a brief recess. I'm going to do everything I can to start promptly. And we just did the devotional, but are there any announcements before we move into a Senate resolution? We have a Senate resolution to take up at this time, SR 21, Senate resolution suspending Senate Temporary Rule 10A and calling for a meeting of the Joint Rules Committee to suspend the legislative face mask policy, which was introduced by Senator Benning. Please listen to the reading of the resolution by title only.
SR 21, Senate resolution suspending Senate Temporary Rule 10A and calling for a meeting of the Joint Rules Committee to suspend the legislative face mask policy.
Now you've heard a reading of the resolution. In my discretion, I'll treat the resolution like a bill and refer it to the Committee on Rules. The senator from Caledonia is recognized.
Thank you, Madam President. I move the rules be suspended and the Rules Committee be relieved of SR 21 and that SR 21 be taken up for immediate consideration.
The senator from Caledonia has moved the rules be suspended and the Rules Committee be relieved of SR 21 and that SR 21 get consideration. Are you ready for the question? The senator from Windham is recognized.
Thank you, Madam President. As is our custom in this chamber, when we are going to ask for a rule suspension on a bill or on a resolution, it is customary to let leadership know of such a request. That has not happened this morning. I would urge the senators to vote against the rule suspension. Thank you, Madam President.
Are you ready for the question? The senator from Caledonia is recognized.
Madam President, is this discussion debatable?
Yes.
We confer with the secretary.
Rule suspension is
Motion for rule suspension is debatable.
Madam President, am I recognized?
The senator from Caledonia is recognized. Was just recognized.
Thank you. Madam President, I appreciate the pro tem's thoughts. The issue is not a discussion, quite frankly, for leadership, nor is it a discussion for any one particular caucus. The Senate is the ultimate arbiter of the rules, not even the Rules Committee. So I have brought this appeal directly to the arbiter of this discussion. But this actually does call for our Rules Committee representatives to be given direction from this body. I can spend some time talking about the actual attempt here. There's actually a second document that I'm hoping will be passed out for folks to look at that was attached to this. Maybe you have it. Maybe you do.
I confirm just briefly that all senators have a copy of the resolution. And also the attached document. Does anyone not have documents?
I'm sure everyone does, Madam President. So let me start with the smaller of the two documents. That is the COVID report as of today in Washington County. There are 3 levels of CDC requirements: high, medium, and low. In high category, CDC recommends wearing a face mask. In the medium category, the CDC recommends talking to your healthcare provider to see whether you need to wear a face mask. And in the low category, the CDC does not make a recommendation of anything other than you have a choice whether to wear a mask or not.
Point of order, Madam President.
The senator from Bennington.
Madam President, I thought we
Point of
were
order.
discussing whether or not to suspend the rules. We seem to be debating the actual resolution. that was sent to the Rules Committee by the president. So I'm a little confused. I thought we were sticking to a debate about suspending the rules.
Let me confer with the Senate Secretary, but again, just to recall the question, which is that whether the rules should be suspended, and the Rules Committee be relieved of SR 21, and that SR 21 be taken up for immediate consideration. The question really is around whether the rules should be suspended. And to a certain extent, that does briefly get into the substance of the bill, but the substance of the resolution really should be taken up when there's consideration of the substance of the resolution, which is not this motion.
I appreciate that, Madam President, which is why I have not talked about the resolution. I am concentrating on the question of whether there should be a rules suspension. And I believe I have the right to ask for a inquiry.
The senator from Chittenden is recognized.
Madam President, you just motioned a ruling to refer SR 21 to the Rules Committee. And the senator from Caledonia did not object to that ruling, but is now asking us to suspend rules, leave the committee of SR 21. My inquiry is SR 21 immediately referred to the committee, or is it not like every other motion and bill that we take action on, where in fact it is transferred at the end of orders of the day?
It depends on how the vote goes and certainly whether it ultimately is referred to the committee. The question right now is simply whether the rules should be suspended and whether it should be taken up for immediate consideration.
But perhaps I could just clarify. I believe the senator from Caledonia, it's obvious what his goal is, missed the opportunity to object when the president made the action of referring SR 21 to committee. Now, the motion is to suspend rules in order to relieve SR 21, to relieve the committee of SR 21. My inquiry is, does the committee actually have it already, or wouldn't that happen at the end of the orders of the day when the bill is actually referred to committee physically?
The bill has already been referred to committee. So the motion is to suspend the rules now and to take it up for immediate consideration.
Thank you, Madam.
Yep.
Apologies for the time.
The senator from Caledonia is recognized.
Thank you, Madam President. We have an operating government system that has to go by its own calendar. If we place this resolution in the Rules Committee, we all know it will take a great deal of time to have the Rules Committee bring it in, take testimony, the normal course of things that it would normally be subjected to as a piece of legislation. We're all cognizant of what is going on around us. And even this morning, as I was coming in, listening to VPR have a discussion with the head of CDC, the reason why she believes it is not necessary for the public to be wearing masks anymore in this country. We have all been hearing what's going on, and we also have been witness to our own colleagues struggling to get through reading legislation on the floor because their glasses are fogging up. We have to learn how to be courageous. We have all abided by the CDC guidance, by the medical guidance of Dr. Levine. We have done wonderfully in getting this building equipped with remote capacity, practicing social distancing when necessary, and having ourselves abide by expectations. Expectations have changed. I am asking that the rules be suspended to take up this discussion immediately because I know if the bill goes into committee, we're still having this conversation over the next 2 weeks instead of dealing with it before we leave for the weekend. With that, I'll rest.
The senator from Chittenden is recognized.
Thank you, Madam President. I will be voting against the movement to suspend the rules. I'll just briefly explain why. At the beginning of the pandemic, my friend, Senator from Caledonia, was himself on the Rules Committee. And the Rules Committee operated efficiently and without any undue delay. I believe they'll do the same thing with this resolution, and they will report back to us quickly. I think we should avoid discussion and move on. Thank you very much.
Are you ready for the question? Again, the question is, shall the rules be suspended and the Rules Committee be relieved of SR 21 and SR 21 be taken up for immediate consideration? The senator from Chittenden is recognized.
Madam President, may I inquire of the maker of the motion?
You may.
Can the senator from Caledonia tell us when leadership of the Rules Committee was first made aware of this proposal?
This morning, I'm assuming moments ago.
Thank you. Thank you, member. I would rise as a committee chair to say that most of us in leadership positions do not like surprises. And the body is a deliberative body that tries to work out any kind of differences. While I might support this resolution on its merits, I probably can do it. I think every person in leadership, and this goes to the Rules Committee in this case, has an opportunity to respond to what's being presented with timely notice. And it shouldn't be rushed through without the Rules Committee given an opportunity to consider it. So I will be voting against this motion. Thank you.
Are you ready for the question? And the question is, shall the rules be suspended and the Rules Committee relieved of SR 21 and that SR 21 be taken up for immediate consideration? All those in favor, please say aye.
Aye.
Those opposed, nay. No. The ayes appear to have it. Excuse me. The nays appear to have it. And the motion to suspend the rules and to relieve SR 21 of the Rules Committee and that SR 21 be taken up for immediate consideration is not done. Thank you. We have House bills for reference today. HR 244, an act relating to authorizing the natural organic reduction of human remains, which was introduced by Representative Partridge of Windham and others. It passed on the House on March 16th. Please listen to the first reading of H 244.
H 200, 44, an act relating to authorizing the natural organic reduction of human remains.
Now you've heard the first reading, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. H 279, an act relating to miscellaneous changes affecting the duties of the Department of Vermont Health Access, which was introduced by Representative Houghton, and passed on March 15th, passed the House. Please listen to the first reading of H 279.
H 279, an act relating to miscellaneous changes affecting the duties of the Department of Vermont Health Access.
The first reading, Health and Welfare. H 500, an act relating to prohibiting the sale of mercury lamps, introduced by Representative Sheldon, passing the House on March 16th. Please listen to the first reading of H 500.
H 500, an act relating to prohibiting the sale of mercury lamps in the state.
The first reading, and the bill is referred to the Committee on Natural Resources and Energy. H 523, an act relating to reducing hydrofluorocarbon emissions, introduced by Representative McCormick, passed the House on March 16th. Please listen to the first reading of H 523.
H 523, an act relating to reducing hydrofluorocarbon emissions.
Now you've heard the first reading, and the bill is referred to the Committee on Natural Resources and Energy. H 572, an act relating to the retirement allowance of interim educators, which was introduced by Representative Webb and others, passed the House on March 15th. Please listen to the first reading of H 572.
H 572, an act relating to the retirement allowance for interim educators.
Now you've heard the first reading, and the bill is referred to the Committee on Government Operations. H 606, an act relating to community resilience and biodiversity protection, introduced by Representative Sheldon and passing the House on March 16th. Please listen to the first reading of H 606.
H 606, an act relating to community resilience and biodiversity protection.
You've heard the first reading, and the bill is referred to the Committee on Natural Resources and Energy. H 655, an act relating to telehealth licensure and registration and to provisional licensure for professions regulated by the Office of Professional Regulation, which was introduced by the Committee on Healthcare and passed the House on March 16th. Please listen to the first reading of H 655.
H 655, an act relating to telehealth licensure and registration and to provisional licensure for professionals regulated by the Office of Professional Regulation.
You've heard the first reading, and the bill is referred to the Committee on Health and Welfare. I believe that does conclude our referrals for today. This brings us to the orders of the day. And we have on the calendar for action S90, an act relating to establishing an amyotrophic lateral sclerosis registry, which was introduced on February 24th, referred to the Committee on Health and Welfare, which reports that it's considered the bill and recommends that the bill be amended as appears on page 1281 of today's calendar, and that when submitted is passed. Please listen to the second reading of S90.
S90, an act relating to establishing an amyotrophic lateral sclerosis registry.
Senator Rutland, Senator Piranzini is recognized for the report of the Committee on Welfare.
Thank you, Madam President. May I read from some prepared remarks?
Okay.
Thank you. Senate colleagues, ALS, better known as Lou Gehrig's disease, named after the late, great New York Yankees first baseman, is an always fatal neurodegenerative disease that affects the nerve cells in the brain and spinal cord. This devastating diagnosis is given to 40 to 50 Vermonters per year and approximately 6,000 people across our great nation annually. At any time, approximately 20,000 Americans are courageously fighting this evil disease. After receiving the diagnosis of ALS, most people will pass away from the disease within 12 to 36 months. Although doctors and scientists continue to learn more and more about ALS each year, the experts in this field will admit that we are still a long way from finding a cure. The ALS Association of Northern New England, based out of Concord, New Hampshire, reported to our committee that there is a national effort to make ALS a livable disease by the year 2030. S90 calls for the creation of a statewide ALS registry by the Department of Health, which would collect data from healthcare facilities within 180 days of the initial diagnosis. The data collected by the Department of Health could help identify if there are cluster areas of ALS in Vermont, what environmental factors could have possibly contributed to Vermonters having ALS, and data points that doctors and scientists can disseminate to help with future research. At this time, I'd like to turn to the bill, and starting in section 1, we have the definition section, and the subsection 172 establishes an ALS registry. It directs the Commissioner of Health to establish a statewide population-based ALS registry system and to adopt rules necessary to effect the purpose of the chapter, including data to be recorded and which state healthcare facilities and healthcare providers are required to provide this data. All ALS cases diagnosed or treated in Vermont shall be reported to representatives of VDH. Directs the Commissioner to establish a training program for the personnel at participating healthcare facilities and control program for ALS data, and requires the Commissioner to collaborate and cooperate with clinicians and epidemiologists and publish reports on results of the studies. Commissioner is directed to collaborate in studies with the National Institutes of Health and Centers for Disease Control and Prevention in providing ALS incident data. In regards to participation in the program, any healthcare facility diagnosing and providing treatment to patients with ALS are required to report each case of ALS to the Commissioner of Commissioners representative within 180 days of admission or diagnosis. If a facility fails to report, the Commissioner or Commissioner's representatives can enter the facility and obtain the information. Requiring healthcare providers, this requires healthcare providers diagnosing or providing treatment to patients with ALS to report within 180 days, as earlier mentioned. Reporting healthcare facilities and providers shall include demographics, diagnostics, and treatment information requests by the Commissioner. In regards to confidentiality, exempts all reports, information reported from PRA. Also exempts all identifying information regarding an individual's records, written reports, and statements that are procured by the Commissioner and the agency. And the information is kept confidentially and used solely for the study of ALS and future treatment. Disclosures allows the Commissioner to enter into agreement to exchange information with any other ALS registries to obtain complete reports for residents of Vermont diagnosed or treated with other states, and other states with residents being diagnosed or treated in Vermont. Also allows the Commissioner to give confidential information to other states that have ALS registries or health researchers to collaborate on a national ALS registry or collaborate on control prevention research studies. This bill prohibits an action from damages arising from the disclosure of confidential or privileged information and can be obtained against a person or employee who participates in good faith in the reporting of the ALS morbidity and mortality data.
Part of it.
Liability, it prohibits the license of a healthcare facility or provider can be detained, suspended, or revoked for good faith disclosure of this information. The bill calls for the Department of Health to apply for grants and directs VDH to seek and apply for grants to fund the registry. As part of its FY24 budget presentation, the Vermont Department of Health is required to direct any grants that it applies for are awarded to identifying funding sources. The effective date would be July 1st of 2022, except Section 1, which would take effect on July of 2023. I want to make it clear to my colleagues in the Senate and you, Madam President, that this bill creates a registry system to collect data points. This bill should not give false hope to Vermonters that we are close to finding a cure. But could this bill help get us one step closer to having a better understanding of this mysterious disease in Vermont? Surely we think so. Madam President, as I conclude, can I offer a personal story to my report?
May.
During my first days in the Senate last year, Senator Ginny Lyons asked if I wanted to be a co-sponsor on a bill that would create an ALS registry. I jumped at the opportunity to be a co-sponsor on this bipartisan bill, not only because it makes good policy, but because of my personal knowledge of this disease. In 2018, I developed some mysterious symptoms that largely could not be explained. Many of these symptoms mimic those of Lou Gehrig's disease. For months, I lived with a great fear that I had developed ALS, and my family did too. And only after many tests, several doctors, and finally a few trips to Dartmouth Hitchcock Medical Center, ALS was not my diagnosis. One of our great witnesses, Dr. Stommel, was the neurologist that I spent time with at Dartmouth. These mysterious symptoms finally improved and I was able to move on with my life. The reality is, for those diagnosed with ALS, they simply cannot just move on with their lives. Progressively, their lives will decline to a point of needing constant care, then paralysis, and then finally death. This data collection bill is a step in the right direction. The Senate Health and Welfare Committee heard from the following witnesses. David Englander, Senior Policy and Legal Advisor for the Department of Health. Karen Hammer-Williamson, Care Services Coordinator of the Vermont ALS Association of Northern New England. Nolan Langwell from the JFO office. Dr. Mark Levine, Commissioner of the Vermont Department of Health. Senator Ginny Lyons herself. Katie McClin from Alleged Counsel. Paul Mehta, Principal Investor, CDC. Ann O'Brien, Wellness Nurse from the Cathedral Square. Dr. Elijah Stommel, Neurologist, Dartmouth Hitchcock Medical Center. Dr. Ruck Tandem, Neurologist from the UVM Medical Center. And Sarah Voss, State Toxicologist and Department of Health. The committee vote was 4-1-0, and we would ask for your support. Thank you.
The question is, shall the Senate amend the bill as recommended by the Committee on Health and Welfare?
I don't have an amendment. I think it's just favorable till the bill be read a third time because it's.
Okay. My correction. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Aye. Those opposed, nay. The ayes have it, and you've ordered third reading of S90. We have on the calendar for action S161, introduced on January 4th, was referred to the Committee on Finance, which reports that it's considered the bill and recommends the bill be amended as appears on pages 1281 to 1283 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S161.
S161, an act relating to extending the baseload renewable power portfolio requirement.
The senator from Addison, Senator Bray, is recognized for the report of the Committee on Finance.
Madam President, I'm reporting S161, which appears in today's calendar on page 1282. This is a bill that has fits in a theme that we've been experiencing in the last year and a half repeatedly, which is that COVID has been such a disruptor to so many programs that progress that once a single year has taken longer than thought. And this relates to another project underway with continue the operation at the Reigate Biomass Energy Generating Facility in Reigate, Vermont, a 22 megawatt facility. It is currently the rate for it, and it operates under Section 8009, the base load renewable power portfolio requirement in Vermont Law Title 30. And that law originally established a period of operation from November of 2012 through November of 22. Last year during discussions, we moved that date, the 22 date to 24, and asked the owners to investigate ways to improve the operations of the plant, and in fact, to use more of the waste heat that it has. They've made progress on investigating alternative uses, but things have been slowed down, and it was the judgment of the Finance Committee that they were making meaningful progress, but needing additional time. So the changes that you see on page 1282 are all related to date changes that allow them to continue their effort to improve the performance of the plant and continue its operation. The first change is, again, to the underlying statute in Title 30. The date of 2024 is pushed out an additional year to 25. The next two sections, 2 and 3, amend session law that was related to, in section 2, the rate. Since it operates with a rate paid by the PUC, we needed to extend the period and define the rate to be used. That's defined in section 2. And you see another date pushed out through 2025. The last section, section 3, where we have a report coming back. We have moved the date from 2023 to 2024. So all in all, it's an extension of the current program in order to ensure the long-term viability of the plan. That, pardon me, the committee vote on this was 7-0-0, and we heard from the following witnesses. Barry Bernstein, past president, board of directors, Washington Electric Co-op. Ellen Chikowski, legislative counsel. Greg Faber, analyst of the Public Utility Commission. Ken Jones, economic research analyst of the Agency of Commerce and Development. Ted Haney, power supply manager, Vermont Electric Cooperative. Stephen Knowlton, president, board of directors, Washington Electric Co-op. Brett Long, deputy commissioner, Department of Economic Development. TJ Poor, director of planning, Department of Public Service. Doug Smith, chief public supply executive, Economic Power. Rachel Schmoker, co-director of Biofuel Watch. Michael Snyder, commissioner of the Department of Forest Parks and Recreation. Charles Storrell and Dylan Zwicky, both lobbyists on behalf of the Reigate Power Station. And that completes my report. For your support.
The question is, shall the Senate amend the bill as recommended by the Committee on Finance? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Finance. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of S-160. We have on the calendar for action S-162, an act relating to the collective bargaining rights of teachers. It was introduced on January 4th, referred to the Committee on Education, which reports it has considered the bill and recommends that the bill be amended as appears on pages 1283 to 1285 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S-162.
S 162, an act relating to the collective bargaining rights of teachers.
The senator from Washington, Senator Perchlik, is recognized for the report of the Committee on Education.
Thank you, Madam Speaker. May I speak to the bill as introduced as well as the committee's amendment?
Madam President.
Oh, thanks.
Aye.
So S-162 is introduced. If any of the senators received communications from constituents on the bill, is very likely on the section that your committee removed and is not in the amendment. But I bring it up because it's something that I think will come before the chamber again. And that was a provision that would have provided more protection for teachers as they pursue their professions and be able to apply for, interview for, and accept jobs at another school while they're still working at their current school. We wanted to do this to support teachers, but we also wanted to do it to support schools and students. We were working on a compromise between the teachers unions and the school administrators on how we would do that, how we would have kind of a hiring season. We thought we were close to a compromise that would be supported by all. We weren't able to do that by crossover, and we didn't want to put something forward that wasn't, we thought was have high confidence that was the right thing to do. So we pulled that out of the bill. So that controversial section is not in the bill. So on to the actual strike all amendment that's on page 1283 of today's calendar. Section 1, you will see adds language to Title 16. It's in B here. That basically says that the teacher is employed under a collective bargaining agreement, that the provisions in the collective bargaining agreement around dismissal or non-renewal of a teacher's contract, that the contract, that collective bargaining contract will control on how those procedures take place. We have statutory language on how things are dealt with when a teacher is dismissed, and that is in C and D. So B dismisses C and D if there's a collective bargaining agreement. And this is needed in statute because there was a case from a teacher in Northfield that was suspended. The teacher appealed the suspension, but didn't do within the 7 days that's in the statute. And they did that because in the collective bargaining agreement, it said they had 2 weeks. They did it within the 2-week deadline, but not within the 7-day guideline that's in the statute. This was appealed up to the Supreme Court. The Supreme Court said that the statute controls, even though there was a binding contract between the two parties on these procedures. We wanted to correct that, and the way the unions and the schools operated was always on the contract, even though we had the statute. So this just puts into statute what the unions and school administrators were practicing, and that is to go by the binding contract, the collective bargaining agreement, instead of the statute. So that is section 1, as well as some clarifying languages and language updates. Section 2 is non-interference with the right to testify. This section just clarifies that any school employee can testify in front of the legislature, legislative committee, or the Board of Education without fear of being disciplined by their employer. This is important because we had a reported case of this happening to a teacher, and also when we sometimes ask teachers to come and testify, they are a little worried about whether they would be disciplined. So this makes it clear that they are not subject to discipline just for testifying in front of us or in front of the Board of Education, with 2 caveats. One is that the teacher or the school employee, this applies not only to teachers, but to a principal, to a cafeteria worker, anybody employed at the school. The 2 caveats are is they can't divulge any confidential information. They still would be subject to discipline if they release confidential information. And the other clarification is that the teacher or the school employee has to say on the record that if they're not have permission to speak for the school, they have to say on the record that they're just speaking for themselves. If they have permission to speak for the school or their employer, they can do so, but they have to clarify if they're just speaking for themselves. And that's really what the bill is, just those 2 sections. Section 3 is the effective date, takes effect on passage. Your committee voted 6-0-0. I will give you the people we heard from on this bill. We heard from Legislative Counsel, the bill sponsor, who I thought was very Spelling. Heard from 2 teachers, one from Berrytown School and Randolph Union School. We heard from 2 principals, Randolph Elementary School, North Country Union High School, 3 superintendents, one from Montpelier Roxbury School, the Colchester School, and the Caledonia Central School. And we heard from the 4 executive directors, which the Committee on Education hears a lot from: the Vermont School Board Association, the Vermont National Education Association, the Vermont Superintendents Association, and the Vermont Principals Association. And with that, Madam President, I will answer any questions.
The question is, shall the Senate amend the bill as recommended by the Committee on Education? Are you ready for the question? The senator from Chittenden is recognized.
Thank you, Madam President. I wonder if I might inquire of the reporter.
May.
In section 2, we protect teachers and other workers of the school district from ramifications for testifying in the legislature. And I'm curious, do they already have that protection for speaking at a school board meeting or with members of school board?
Madam President, that did not come up in my recollection in the testimony that we heard, but I think it's a good question. I think it's something that we should look into, and I'm willing to report back before third reading.
Thank you, Senator. Thank you, Madam President. I do think it's important. I hope we do have that already. You know, I've in my time here wrestled with this issue for state workers coming to the legislature. I remember some kind of rule that was applied to state workers that they were specifically barred from talking to legislators, even if they ran into us at the supermarket. I recall that in many years ago, we fought to undo that, and I would say the same principle applies here. So I look forward to getting that clarification. Thank you.
The senator from Washington is recognized.
The senator's comments reminded me of one thing I was going to let you know, is that this language about testifying mirrors the language that we have about state employees testifying. It's basically the same language that we have for how and the conditions of testimony from state employees.
The question is, shall the Senate amend the bill as recommended by the Committee on Education? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee. The question now is, shall the bill be read the 3rd time? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and you've ordered 3rd reading of S 162. We now have on the calendar for action S 201, an act relating to the use of leg hold traps, introduced on January 6th. The Committee on Natural Resources and Energy, which reports it has considered the bill, recommends the bill be amended as appears on pages 1286 of today's calendar, that when so amended, the bill ought to pass. Please listen to the 2nd reading of S 201.
S 201, an act relating to the use of leg hold traps.
The senator from Addison, the chair of the Committee on Natural Resources and Energy, is recognized for the report.
Thank you, Madam President. And I'm reporting on Bill S-201, an act relating to the use of leg hold traps, and appears on today's calendar beginning on page 1286. As members of the Senate may know, we've had a number of Fish and Wildlife bills this year, and this year, as in every year, they ended up generating some controversy. And I think at heart, the controversy that appears and reappears regularly differing points of view of 2 communities, those who engage in trapping and fishing and those who do not. The hunting, fishing, and trapping community points rightly to their constitutional right to take game, and that game is held in public trust. The latter group cites their shared ownership in all game, and therefore they feel it's appropriate that they have influence over the practices of the management of game. The committee listened very carefully to both sides and crafted bills that strike a balance between the perspectives. S201 advances animal welfare, preserves and revises trapping provisions, and revises trapping provisions. And while no side is entirely satisfied, we think we have found a reasonable and respectful compromise. In addition, the committee was also mindful of just how divisive these issues can be. Sometimes people refer to them as culture wars. At a time where we're all experiencing many tensions that are moving us towards greater division, we felt that it was all the more important to come up with a compromise and build a progress towards a less contentious future by actively engaging all parties in game management decisions. And that's what this bill provides for. So turning to the bill itself, again on page 1286, when it comes to trapping, which is an evolving practice over time, technically speaking, in terms of our understanding of its rules, there are now published national best management practices, which, although they may be adopted by individual trappers, they are not required in the state of Vermont. And so the bill requires that the Commissioner of Fish and Wildlife submit this to committees of jurisdiction in the legislature, as well as the Fish and Wildlife Board, recommended best management practices for trapping. And that must by January 15th, 2023. So at the beginning of next year. Then that recommendation is taken by the Fish and Wildlife Board and informs their rulemaking, which is their normal role. That rule, once developed, just to remind people, will also then be moved into the normal Procedures Act and will eventually go before ELSA. So there is going to be discussion as the commissioner develops the guidelines. There's going to be discussion, including public comment and engagement in the Fish and Wildlife Board process. And then the APA, Administrative Procedures Act, also affords all Vermonters the same opportunity again. There's an emphasis on engagement. So the bill then goes and lays out what the requirements are in terms of what the BMPs shall address. It gets into what kind of trapping devices, how they shall be maintained, the techniques and placement of them. We add a new provision that requires that it be the placement of traps, except for in nuisance trapping, in other words, trying to remove animals from, could be your backyard, that they need to be placed at a safe distance from public trails, class 4 roads, playgrounds, parks, and other public locations where people may reasonably be expected to recreate. That addressed a concern on the part of some citizens that they could be on a walk with their dog on a path and their dog might get caught in such a trap. We're trying to avoid the rules will address avoiding those kinds of conflicts. The rules continue on for how animals trapped shall be released or dispatched, and then the rule that developed by the commissioner will also include recommendations for possible funding. So we know that for many trappers, they have significant investment and equipment, and if we're going to move to BMPs, and that requires replacement of equipment, we don't want to create a hardship for those individuals to comply with the law. We've already heard that there are opportunities to provide funding to ease that transition, and we ask the commissioner to bring forward recommendations to help that be an affordable transition for those involved in trapping. In subsection C, we again lays out the provision that the commissioner in developing BMPs engages the public And then in section 2, we add a new sub B, and then it says, on or before January 1, 2024, the Fish and Wildlife Board shall revise the rules regulating the trapping of fur-bearing animals in the state. Revised rules shall be at least as stringent as best management practices for trapping recommended by the Department of Fish and Wildlife to the General Assembly. The committee vote on this was 5-0-0. So I'll conclude where I started. For some people, I'd say, I've never been satisfied with the notion that if you have someone unhappy with the bill, that you achieve a place of balance. But I think that is actually true in this case. There are people who wanted to do more on either side, but I think we found a path forward, and the committee asks for your support.
The question is, shall the Senate amend the bill as recommended by the Committee on Natural Resources and Energy? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes appear to have it. Ayes do have it, and you've amended the bill as recommended by the Committee on Natural Resources and Energy. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
Ayes appear to have it. The ayes do have it, and you've ordered third reading of S-201. We have on the calendar for action S-250, an act relating to enhanced administrative and judicial accountability of law enforcement officers, January 13th. It was referred to the Committee on Government Operations, which reports it has considered the bill and recommends that the bill be amended as appears on pages 1287 to 1292 of today's calendar, and the bill ought to pass. Please listen to the second reading of S-250.
S-250, an act relating to enhanced administrative and judicial accountability of law enforcement officers.
The senator from Windham, Senator White. Have Senator White.
Thank you, Madam President. And I believe the senator from Chittenden, Senator Rom Hinsdale.
Thank you. The senator from Chittenden, Senator Rom Hinsdale, is recognized for the report of the Committee on Government Operations.
Thank you, Madam President. That may also be related to a small technical amendment that will be introduced later that's under the name of the senator from Windham. Public safety relies on trust. Trust that when a law enforcement officer is called to the scene of a crime, takes the witness stand in a criminal case, or interrogates someone suspected of a crime, they are protecting and serving all who they interact with fairly, equally, and impartially. S-250 enhances administrative and judicial accountability of law enforcement officers to continue to build that trust on behalf of all Vermonters. It achieves this by 1, expanding data collection and reporting by law enforcement, 2, creating a law enforcement officer database to store potential impeachment information concerning law enforcement officers so that it can easily be accessed and disclosed by a prosecutor, 3, mandating the recording of all custodial interrogations related to felony investigations, and 4, commissioning a report on deceptive and coercive law enforcement interrogation techniques. Section 1 of S-250 amends 20 VSA 2366 to expand law enforcement data collection. Specifically, an amendment to subsection E1 mandates that beginning on September 1st, 2022, data concerning all law enforcement encounters must be collected by law enforcement agencies. Currently, law enforcement agencies are mandated to collect and report roadside stop data, including the circumstances, outcomes, and demographics of the individual subject to a roadside stop. We know that this has yielded data that is as illuminating as it is concerning. The most recent data analyzed in a report this January shows Vermont traffic stops dropped 40% in 2022 to their lowest rate in years. But the long-standing gap between black and white drivers remained in place that year. As in previous years, the stop rate for black drivers was twice as high as for white drivers. Black drivers were also 3 times more likely to be searched than white drivers, even though they were actually less likely to have contraband that led to a ticket or arrest. We need to expand on this critical data collection to understand additional disparities, such as the use of force leading to injury or death. This is information that is currently not collected or aggregated across all law enforcement agencies, and furthermore, should be made widely available and searchable by the general public. The committee heard testimony that law enforcement agencies are already beginning to collect additional data on all law enforcement encounters, including use of force. This bill just provides a directive so that the data can be stored, analyzed, and made available, including reporting annually to the legislature. Continuing, the proposed amendment to subsection E3 mandates that no later than July 1st, 2023, law enforcement agencies provide all data collected to the Executive Director of Racial Equity and the vendor selected by the Vermont Criminal Justice Council to store and analyze the data. And that section will be where there is a forthcoming amendment. The changes to subsection E4 and 5 provide clarity about how to report the collected data to the legislature, specifically designating committees to receive the report and directives about what is included in the report. Section 2 of S250 adds a new section 2370 to Title 20. It creates a law enforcement officer information database, what is commonly known as a GILEO database, named for the landmark U.S. Supreme Court decision that clarified the prosecution's requirement to disclose evidence to the defense that may be used to impeach the prosecution's witnesses. For those familiar with the court case, it is tempting to pronounce GILEO with two hard G's like Giglio. I want to thank the director of the Civil Rights Unit in the Attorney General's office for sharing the recorded oral argument before the Supreme Court, so I can authoritatively tell you that it is a GILEO database. This database catalogs potential impeachment information concerning law enforcement agency witnesses or affiants. It is designed to enable a prosecutor to disclose such information consistently, appropriately, and pursuant to legal obligations. The Vermont Criminal Justice Council is responsible for maintaining the database, and information stored within it includes any finding of misconduct relating to the truthfulness or possible bias of a police officer, any past or pending criminal charge brought against a police officer, any allegation of misconduct bearing on truthfulness, bias, or integrity of a police officer that is the subject of a pending investigation, any prior judicial findings that a police officer testified untruthfully, made a knowingly false statement in writing, engaged in unlawful search or seizure, or illegally obtained a confession. A finding or pending allegation that either casts substantial doubt upon the accuracy of a police officer as a witness that a prosecutor intends to rely upon in proving the case or admitting evidence. Information that may be used to suggest that a police officer is biased for or against a defendant, or information that a police officer's ability to perceive and recall truth may be impaired. The law enforcement agency must report any information required to be cataloged in the GILEO database within 10 days after discovering the information. Each state's attorney and the Attorney General have access to the database for the purposes of complying with their disclosure requirements in the prosecution of crimes. Otherwise, the database is confidential and shall not be accessible by any other entity, including the Vermont Criminal Justice Council, unless access is in furtherance of the council's duties. The entities with access are permitted to produce information pursuant to a proper public records request. This section represents a critical step forward in documenting officer accountability to representing information honestly and accurately, which is vital to building trust and ensuring officers who take the witness stand have full credibility in weighty criminal proceedings. Section 3 of the bill amends Section 5585 of Title 13, which concerns the recording of custodial interrogations. Currently, all custodial interrogations conducted during a felony homicide or felony sexual assault investigation must be recorded. For background, custodial interrogations occur when a police officer attempts to elicit an incriminating response and the person being questioned would consider themselves in custody. In addition to a few changes to language ensuring gender neutrality, the amendment to Section 5585 would mandate that custodial interrogations conducted during any felony investigation are recorded unless an existing statutory exception applies. So, the change to the law is simple but significant. All felony investigation interrogations are recorded rather than just those for homicide and sexual assault. Relatedly, Section 4 of S250 creates a study on deceptive and coercive methods of law enforcement interrogation. The Joint Legislative Justice Oversight Committee will select an organization, this is where the amendment for the Justice Oversight Committee comes in, with assistance of the Vermont Criminal Justice Council and the Council on State Governments to submit a written report studying the use of such tactics. The report will focus on a few topics. Number one, the types of interviewing and interrogation techniques used by law enforcement. Two, if providing false facts about evidence during an interview can result in an involuntary confession or admission of a crime. Three, when confessions or admission procured by providing false facts should be inadmissible in court. Four, if there is an appropriate age and circumstance to prohibit coercive techniques when interviewing juveniles. And five, any legislation, initiatives, or programs for the General Assembly and law enforcement to consider improving current practices. More and more states are banning the use of false information presented in such a way that it coerces an involuntary confession in custodial interrogations, such as false evidence or promises of leniency. Studies show that juveniles are 2 to 3 times more likely to confess to crimes they didn't commit when subjected to forceful interrogation tactics. While the Department of Public Safety attests to training that moves away from these tactics, we heard during testimony that the Criminal Justice Council had advertised a local law enforcement training on their website for the READ technique, which involves the investigator, and I quote, first imagining and then offering the suspect various psychological constructs as justification for their behavior. This technique is illegal in several Western European countries, and many cases in the United States have been thrown out due to false confessions being elicited and brought to light in subsequent appeals. In summary, S250 makes important progress toward increasing law enforcement accountability in the state of Vermont, and therefore increasing trust in an institution for which trust and accountability are necessary to advance equitable and meaningful public safety. The committee received testimony from the Windham County Sheriff, the Deputy Director of the Vermont Criminal Justice Council, the Executive Director of Racial Equity and Chair of the Governor's Task Force on Racial Equality in the Agency of Administration, the Vermont Organizing Director of Rights and Democracy, the President of the Windham County NAACP, the Orleans County Sheriff, the Director of Public Policy and Advocacy for the Vermont League of Cities and Towns, the Deputy Director of the State's Attorneys and Sheriff's Department, the Executive Director of Rights and Democracy, the Chair of the Racial Disparities Advisory Panel, the Office of Legislative Counsel, the Chief of Police of Montpelier, also representing the Vermont Police Association, the Advocacy Director of the ACLU of Vermont, the Commissioner of the Department of Public Safety, the Statewide Campaigns Organizer for Rights and Democracy, the Chair of the Vermont Criminal Justice Council, the Director of the Civil Rights Unit of the Office of the Attorney General, the Director of the Vermont Crime Information Center, and the Municipal Policy Advocate of the Vermont League of Cities and Towns. Madam President, as you can deduce from this witness list, your Government Operations Committee took significant testimony and looked comprehensively at a number of reforms that we believe take a significant step forward in oversight, accountability, and most importantly, the public trust in the institution that has the most government-sanctioned power to take away freedoms, civil liberties, and lives. Your Government Operations Committee passed this bill on a vote of 4-1-0, and we ask the body for their support. Thank you.
I believe the Senator for Windham is now recognized for the amendment.
Yes, thank you, Madam President. May I ask for a brief recess before we go to the amendment?
You may, and just for everyone's clarification, the amendment is not.
It's not in the calendar,
but it has been
there in time.